Welcome to our Farm Life podcast. I'm Jonathan Stork, partner here at Shakespeare Martineau, and today I'm joined by Andrew Wilkinson, also a partner in our contentious probate team. In today's podcast, we will be looking at inheritance disputes in a farming and agricultural context, exploring the complexities of them and how best they can be avoided. And we've decided to call it Farming, Family and Fairness because I think that brings together quite a few of the different strands that tend to be prevalent in these kind of disputes. And we will come on towards the end to discuss how best we can try and mitigate these types of disputes because, to be fair, they're difficult. They're difficult on a legal basis. They're difficult factually. They can be expensive. And that really leads to a position where they're best avoided. The structure of this is going to be fairly informal. Andrew and I are going to discuss our thoughts relating to this topic, our experiences. And I would really encourage anybody who's got any questions as we go just to shout out and let us know their questions, and hopefully we can sort of weave those questions into how we go. Equally, at the end, we'll open up the forum for any questions. So just to get started, starting for real, Andrew, my general experience of these cases is that they're particularly interesting. And I think they're particularly interesting from a litigator's point of view because we don't have the main witness there because almost by definition that person has passed away and is no longer able to give evidence in the case. The problem that presents, and I always find this when I say to a client, this is a interesting case, is that that's not necessarily good news for them.
Clients don't like interesting cases because interesting cases are complicated and technical and not easy to sort out.
That's right.
So, absolutely, I agree with that.
Yeah. So as I say, I mean, they're best avoided and mitigated as best possible. But I thought we'd sort of take people through first the common themes in these types of cases. Usually, the nature of a farming business is often that it's a family relationship, and that is not entirely unique in the business world. But I think certainly as a general theme for these kinds of disputes, it has a uniqueness about it, and often those relationships go obviously back potentially many decades, potentially intergenerational, and they involve the usual kind of maybe stresses and strains in a relationship that you would expect in any family relationship. Some of them seem to me like they might be the sort of usual relationship that you have post-Christmas. They have that kind of everybody's been in the same place for the same time, and there's the strains that go with that. Is that your experience?
I think that's right, and I think that's often the situation I see is that often in families where relationships have perhaps deteriorated, as a result, families have become dispersed, and they don't see each other. But in these farming cases, they're all, often literally living on top of each other, in the same building, in the same village, on the same farmstead, and it just means that those kind of tension, those opportunities for things just to kind of explode and kick off are so much more. There's so many more opportunities for that sort of, those sorts of disputes to arise. And it's just that it's the sort of nature of the assets as well, which is that that there's that huge importance and significance of owning land, and it's not, as you say, often these disputes have gone back generations and generations, and it's not just about owning some land; it's about owning that piece of land, and the real value in particular assets and wanting particular assets. And of course, the thing we've seen over the last few years as well is that we've seen agricultural land values go up. And of course, we've also seen development whereby, they have assets that, may have had some value have potentially significantly increased in value as a result of development. So again, that's made particular assets even more valuable than they once were. And again, has kind of, you couple that with the kind of almost sort of, the obsession with land and owning land. And it's a recipe for, big fallout when things go wrong.
Yeah, it's that bind to the land as well, isn't it? Because the nature of a farming business and farming family is that, the blood, sweat and toil that's put into these businesses and physically into the land in a variety of ways really, really binds people to the business in a way which I think is, as I say, I think it's unique in very many ways. And I think that just sort of accentuates the stresses in normal family relationships. In a sense, there's an unnaturalness about having to be in a business with family members, and in a sense, it being inextricable from both family and both from land. So it's kind of almost like it's a melting pot, isn't it? It's a cauldron which really can produce the most sort of epic of disputes in this respect, especially when people's expectations are not satisfied.
I think linked to that is certainly the thing I've seen over the last few years is that sort of more family structures becoming more complicated, and I mean in terms of sort of second marriages, etc., and people entering it, having multiple families, but also I think we're more and more where some family are in the business and some are outside it, and some have left to do other things and have left, and there's that real tension, I think, between the sort of the family wanting to keep the farming business intact, but whilst at the same time making sure that all of the children are treated equally or fairly. And we come back to the fairly point that we talked about at the start of that, and I think that's incredibly difficult to juggle. How do you do that when you've got an asset pot which is often very difficult to do anything with? It's a kind of it's a block of assets, and it needs to be as one in order for it to work. But it's also where all of the family wealth is. How do you kind of ensure that everyone gets a piece of the pie when you've only perhaps got one or two family members actually in the business, and that's really difficult. And I think some of that's been and we've certainly seen complications as a result in recent years as a result of diversification. So where certain family members have put money in of their own in order to diversify, whether it's farm shops, holiday cottages, whatever the business is. But again, just that sort of the asset pot becoming even more complicated, and those expectations going up as a result in terms of what people expect, because they think, well, I'm going to put in 20, 30 grand into this venture, but obviously in return I want whatever back in due course, and when that doesn't happen, then obviously people are unhappy about it.
Yeah, absolutely. And then you can layer on top of that issues relating to succession, and obviously most farming businesses will want to build in succession because that, as I say, that sort of blood, sweat and tears. But then you build in issues relating to effective use of tax breaks, etc., whilst combining that with the friction relating to wanting to treat a range of potentially the children of the family equally in some way, and that, I think that produces a really difficult balance to achieve, which I don't think always is, and that's when we see the sort of cases that come for us, isn't it?
Exactly. I think the other theme as well, I think unfortunately we see, we'll come back to it later in terms of avoiding disputes, is that I think too often advice is taken too late, and or things aren't done properly. You can you can often spend a smaller sum of money trying to get things sorted now. Jonathan, we can verify that you can make a huge saving if you spend some time now in terms of proper advice. It can save an absolute fortune in terms of resolving disputes later on, because at least now you're dealing with things where things are relatively calm, or you hope anyway. Whereas that it's just that situation of someone having died, the grief of that, the sort of family tensions that all come to the forefront, makes it incredibly difficult to resolve these things. So I think, we'll come back to it later, but taking advice early and taking proper advice often doesn't happen. And it's just a sort of, just don't want to spend money, unwillingness to spend money, but it can be, it can be a huge saving overall when you consider the overall cost to the family, both financially and emotionally.
Yeah, I totally agree with that. And I think, again, that is potentially a symptom of how sometimes families work. They work more by nuance rather than sort of being overt about what intentions are. And that's not always the best way in which to run a business. So it reflects that friction, doesn't it? As you say, we'll come on to sort of discuss that.
It's that informality, isn't it? It's the fact that things are often done very pretty informally. Often, in these farming partnerships, everything is run through the partnership. So it's not just the business expenses. You just put everything through it, and it's all very enmeshed together. You can't really separate any. It's because it's all as one, really, and it's that sort of trying to unravel that, as often we're trying to do, can be very, very difficult.
Yeah. So I mean, just in brief, I mean, I always say that this creates something of a perfect storm for a potential dispute, and some of the big cases relating to what we're going to go on to discuss a little bit in a little bit of detail, proprietary estoppel and the Inheritance Act, do come out of this sector because of that perfect storm. So I think, Andrew, what I'll do, I'll just take us through proprietary estoppel, just to give a bit of background to the people listening in. The sort of basic considerations that we see in some of these cases. I think you're going to talk a little bit about Inheritance Act. And it's not to say that one of, it's either or in terms of the legal aspects of these. They tend to be layered. And then you can layer on top of that issues related to partnership and various other issues, but they tend to be multifaceted in that way. So just very briefly setting out proprietary estoppel, and that's a legal sounding doctrine for what is something. It's actually relatively simple concept, although when it put into practice and when you have to evidence these things, it becomes more and more complex. But it is a sort of classic type of case in a farming context. And maybe just to give the sort of example is the best way of doing it. It's where, as I say, for example, you have a son who's worked on the family farm for the whole of his life. He started as maybe helping with the animals when he was 10. He got on the back of the tractor when he was a little bit older than that. He was helping with the hay, etc. And when into his teens, and then went on to work in the farm. He's there helping his mum and dad through that time. He maybe decides not to go to agricultural college. He could have done so. He could have gone away and done other things, could have gone to university maybe, could have gone and made some more money doing contracting work, that sort of thing within the agricultural field. But he stays there because he comes to the impression, built upon conduct by his parents, and perhaps some things said to him, that he's going to benefit from owning the farm in due course. It's the classic one day all this will be yours, son situation. But then he's disappointed upon his parents' deaths. He's not left anything, or maybe he's only left a pecuniary legacy, which doesn't give him sufficient recompense for the time, effort, blood, sweat, and tears that he's poured into the farm over that time. that's the sort of position we see when someone comes to us and says, "Have I got a claim? I've been promised this over time. I'm disappointed. This feels unfair." And that is the sort of essence of a proprietary estoppel case, and it's a multi-stage test. You've got to have a promise. You've got to have that assurance. Then you've got to have reliance upon the assurance, and you have to have detriment. And the case doesn't work without all of those things working together. So you can't, if there's no detriment, for example, say he would have been there anyway, he was well paid during that time, then there would be arguably no detriment, and therefore there'd be no case. So you have to have that combination of those key requirements. Now, all of those, the courts have gone into great detail as to the nature of those constituent parts of a claim over a long period of time, and they've been, in a sense, refined. But I suppose the emphasis that I would put on is that this is an extremely flexible doctrine, which, in a sense, reacts to the facts surrounding it, and each case is entirely dependent upon its own facts. So, for example, what is the nature of a promise? What is the nature of an assurance in the sort of relationships that we've been talking about, where perhaps communication between family members isn't what it always might be, where there's no documentation to back it up. Nothing's been put down in writing. So the courts have sort of wrangled with those sort of issues over a period of time. And it is the case that, conduct this over a long period of time can amount to an assurance. But I think all that really just goes to show the nature of these sorts of disputes is so dependent upon fact and so dependent upon the nature of the relationships between the parties, and particularly between the deceased and the person who's seeking to rely upon the assurance that has been made. And as Andrew, I think, made clear, the problem with that, of course, is it makes a difficult case. It makes it difficult evidentially because most of it's going to be witness evidence, and that can, in some cases, survive or fall on the performance of the witness at trial. And it can also depend upon how a judge makes of it at trial. And that's a sort of notoriously difficult thing to judge. But that's proprietary estoppel in essence, and that's sort of basic tenet of the sort of case we see. And I think that sort of reflects some of the issues that we've previously discussed as a sort of uncertain elements that we see in these relationships.
I think then, speaking of uncertainty, that takes us on to the 75 Act claim, which I don't think gives us any, is equally uncertain in terms of outcome. And I suppose that the starting point in terms of these sorts of claims is that generally in English law, you have complete testamentary freedom. So you can leave your estate to whoever you want. But there's a very large asterisk that says subject to the 75 Act, and that's the Inheritance Provision for Family Independence Act 1975. And essentially that says that if you do not make reasonable provision for certain categories of people, then they can bring a claim against your estate. So the categories of people include spouses, it includes children, it includes cohabitees. So there are a large number of people who can potentially bring claims where they can say, look, I was not reasonable provision was not made for me in this will. And just to sort of bring it to life a bit more in terms of a sort of practical example, the way that I've certainly seen it on a number of cases in a farming context is where the principal asset is the farming partnership, and the remaining partner, there are still other partners who are still alive. And the partner who dies leave his share in the partnership to often his brothers or to his family, to the exclusion of, say, his wife or his girlfriend in some situations. And in those situations where that person has been financially dependent on the on the spouse, on the person who's died, then they will be able to bring a claim. If you're a spouse, you're kind of number one in line. You've got the best claim. That sort of works down in terms of priority. But those people are always going to say, well, look, you should have made provision for me. And the more dependent that person was on the person who has died, the better that claim is going to be. Now, like John said, in terms of the estoppel claims, they turn on their facts. And I suppose 75 Act claims perhaps are less factually sensitive, but the problem with them is that the court, again, as in the estoppel claims, have a huge amount of discretion. Each case turns on its facts. You can't, I've got a case in front of me now. I will almost certainly not be able to find one that's identical that's reported. So each case turns on its facts, and the courts have huge amounts of discretion. And there is enough sort of flexibility within the legislation that essentially allows the court to kind of do what they want. The court has very wide-ranging powers on those claims. So the process isn't particularly mechanical. So it's not like, well, if you're a spouse, you get 10%, or if you're a son, you get 20%. It's all very much discretionary. It all depends on the situation. And on a lot of claims, the main sort of precursor is showing that the person bringing the claim is in financial need. So in a farming context, again, it can be quite easy to get past that hurdle, because often the farm is the main asset, and people often don't have much else outside of that farming, the farming partnership or the farming asset. So it does make those things, those claims can be very strong, and ultimately it's trying to find a way of settling them in a way that doesn't break up the farm, which is often the reason that provision has not been made is to avoid the farm being broken up, and how the court again have balanced that need between trying to preserve the farm for the benefit of the partners or the rest of the family, as against making sure that provision can be made for the wife, the son, the daughter, whoever who has not been made provision for. So again, they are complicated claims. Not easy to advise as lawyers to say, well, look, this is what someone is going to get, because the court has so much discretion. And it does, and on more and more the stuff that we're doing is advising at that early stage prior to someone passing away to say, well, what's the chance of a claim here? And I suppose maybe that sort of takes us on to the next point about how to sort of minimise the prospect of these disputes happening. My view is that you're never going to be able to.
Andrew, shall we just mention the overlay of partnership issues? Because I think just before we get there, I just think that the partnership is the nature of the business relationship, usually through a partnership, whether under a deed, under agreement or not, often has a further complicating factor upon those issues, doesn't it?
Yeah.
And the how assets are treated, whether it's sort of personal property or under the sort of statutory trust of a partnership, often sort of further complicates those issues, doesn't it? I mean, there's plenty of case law about how assets fall, whether as an asset that can be dealt with by somebody through their testamentary wishes, or whether it has to be treated as a partnership asset and therefore has to be treated in that way. I think you referred to that previously briefly, but I think it's just worth raising at that point that there are those issues, and then the issues of having to potentially wind up the partnership following the death, how the assets of the partnership are dealt with, whether there's any claims that come off the back of continued use of the partnership assets over a period of time thereafter. So yeah, I mean, it's just
absolutely, and I frequently see this issue of is it a partnership asset or not, and the amount of hours and time that can be spent over those, what appears to be on the face of it a simple question is surprising. And of course, just because an asset is in the partnership accounts doesn't necessarily mean it's a partnership asset. So there can be huge levels of complexity there in terms of partnerships. And often, as I mentioned at the beginning, these businesses, everything's been put through the partnership. So it's very difficult to kind of separate it out, and everything's been tied up in this one single entity for years and years and years. often without a partnership agreement. So they often doesn't say what you'd like to have is a clear document that says when a partner dies, this is what happens. Often there isn't one, or there is one, but it's about 40 years old and basically not fit for purpose anymore. And the business has moved on leaps and bounds since it was done, and it just doesn't work really. It just for whether on the mechanics of it, the drafting of it, it just doesn't work. So absolutely, partnership. We could spend hours talking about partnership agreements and the problem that they cause, or not having one causes. So absolutely it's a big issue, and it runs through a lot of these cases.
Yeah, I mean, I've got a case at the moment, but not mean to scare people. The issue is what is a partnership asset is still going 10 years after death. So that's a sort of salutary lesson, I guess, that having those sorts of things clear cut is important. As well as a will and accountancy, having accountancy advice, etc. But having those sorts of things, cut is important as well. Yeah, Andrew, have we got a question that's come in?
Yes, we have. We've got a question. Someone death of a business partner, family member set to inherit. They're going through a divorce. Wife wants to sell half his share. And basically they don't want to sell the land. What can they do about it?
Just run that past me again.
So basically, yes, you've got deceased partner in the farm.
Yeah.
Basically, one of the family members who's set to inherit is going through a divorce, and his wife wants to realise his share in the farming business. And they would need to sell land to pay her off.
Yeah, I mean, I'm not sure whether we can sort of go into the specifics because there's probably lots of further information that would be required in order to go.
But I suppose it does indicate a problem that I've certainly seen in terms of it's this. How do you whether you're trying to buy off a 75 Act claim by a deceased partner's spouse or girlfriend, or there were a number of situations that I've seen where a business is going to have to find a way of raising money to buy out a claim, basically whatever that claim might be. And unfortunately, the long and short of it is that the court, if assets have to be sold, they have to be sold. And the court will ultimately force a sale if there's no other way of doing it. So to my mind, it's trying to think creatively about, can you raise the monies in a different way? And certainly what we've seen over the last few years is banks being willing to lend, so partnerships being able to borrow money to buy out claims. So I certainly think that that's worth looking at. Again, you've got development land, which again, may allow partnerships to raise money to buy out these sorts of claims. But ultimately, there is no option but to sell land, and you've got to sell a field or you've got to sell a bit of land in order to raise cash. There's no way around it. And I suppose that's, ultimately the court aren't, when the court are looking at a claim, whether it's an estoppel claim, a 75 Act claim, they will not, they will not say, well, the business should be preserved at all costs. No. If assets have to be sold, the court will order that assets be sold, and that's what will have to happen. So it's a lesson of trying to avoid these disputes and think about ways of avoiding them, and think about ways of ultimately trying to settle them if and when they do come along.
Yeah, I mean, that's right. I mean, the court is not sentimental about these things, is it? And the court is in many ways a very blunt instrument. So, I mean, just looking at that example that the person asking the question has given, I mean, it just highlights everything, doesn't it, that we talked about in terms of the difficulties of the, relationships. In that instance, obviously, you've got a divorce happening along the line as well. So the assets will be, in a sense, up for grabs, which makes for a really difficult situation in those circumstances. I mean, we spend a lot of our time, don't we, Andrew, sorting these out not referring them to court because of the difficulty that the court has in reconciling the issues in a way which is in effect fair. It will make a determination if it has to, if it is caused to by the parties by taking it to trial. But in many instances, that can be a win or lose situation. And in many circumstances, it can lead to an outcome which is not really best for everybody. As I say, it can be a very blunt tool, which doesn't take into account the nuances that we're sort of talking about in terms of succession, in terms of how the business runs, in terms of the future. So just before we come on to how we can sort of best mitigate these things, I just set out to people listening that the majority of these sorts of cases are dealt with through what is called alternative dispute resolution. They're dealt with through either negotiation or through mediation, which is where you have an independent mediator going between the parties to assist them in coming to a determination of the dispute, a resolution, which is always a compromise, of course, between the two parties. So, the vast majority of these claims do not go to trial because they're expensive and because they're extremely acrimonious, but rather come to a resolution in due course. And I suppose, the question for us as practitioners is how do we best advance our clients' position whilst trying to get it to that position as quickly as possible in order to minimise the costs, ensure that those costs are proportionate and reasonable. And that's what we've always got our eye on as practitioners, because the other outcome can, as you say, Andrew, it can lead to fields having to be sold in order to pay for costs, which is not best for anybody.
Yeah, exactly. And I think, absolutely, I'm a huge advocate. I think particularly for mediation, it works incredibly well in these types of situations. I think, as John has said, it's you can achieve so much more in a mediation that you just would never, even on your best day in court, you're not going to get. There's a flexibility in mediation in terms of agreeing solutions to problems that just aren't going to happen if you go to a court. And I think, as we've highlighted today, the court in itself is incredibly risky. Neither John or I are going to sit here and say, well, look, you're guaranteed to win. If you ever hear that from us, we're lying, because it's just not true. You can't predict the outcomes of these cases. And getting in as soon as you step into a courtroom, you're in the hands of the judge. And as we've mentioned, there's a huge amount of discretion here, and there's a huge amount of sort of judicial flexibility around achieving what the judge thinks is a fair outcome, and fair to you or I looks very different to a chancery judge. So mediation is great. You're buying, inevitably you're a client who's involved in it, they're not going to walk away happy necessarily with the deal, but you're buying certainty, and it allows clients to move on. It allows people to kind of get on with their lives. And, they might not be happy the day after, but a week, 2 weeks after, they might think, well, at least that's behind us. We can move on, start afresh, whatever, the solution looks like. And at least it allows people to move on, because it's incredibly expensive, both financially and emotionally. And we see that with a lot of our clients, the toll it takes on them, because, it's hard. And when you're living, often literally next door to, you're seeing your family every day, you're seeing the assets, you're seeing the farming business. It's just, you're reminded of it all the time, and it just takes its toll. So, mediation brings with it that resolving those disputes and just allowing people to kind of move past it, really.
Yeah, absolutely. Which I think sort of neatly brings us on to how best to avoid. It's an interesting question, isn't it? Because sometimes you can't avoid it. And the nature of the business, the nature of families, the nature of how people react, different characters, different personalities, different viewpoints on how businesses need to work, different viewpoints on how restricted assets need to be divided. So, I mean, sometimes it can't be avoided, but I think the best way and the best chance is by being open, by having conversations, and by not allowing there to be expectations which go unrewarded. I think that's I think where, certainly in terms of a proprietary estoppel claim. I think also linking in with inheritance, the 1975 Act claims, that's really where you see the root of them. The root comes from that feeling of unfairness, and not feeling that you've got what you felt the deceased was thinking of giving you or was planning to give you. So from the point of view of the person making the will, it is, of course, and we'll go on to talk about getting the advice, but I think there's things that you can do on the ground in terms of having those conversations, in terms of making sure that people understand where they stand and what's going to happen in the future, having conversations about succession, conversations about how you see it panning out in the future and how that's going to be reflected in testamentary wishes. That's absolutely crucial. That's not to say that those conversations are easy. I mean, they may not be. In certain circumstances, they may feel impossible. But if those conversations aren't had, then it's likely that is going to cause problems in the future. And there is going to be a dispute after the event. So, I mean, my takeaway from this would be have the conversations as much as you possibly can to ensure that you're not leaving people with unfulfilled expectations.
And I agree with that. And I think certainly it's that sort of perfect. We've used the word perfect storm already today, but it's that, the element of surprise has driven many a dispute, and people expecting one thing, realizing that that they're not going to get what they expect, but coupled with the impact of grief is really a toxic, can be a very toxic combination that can lead to some very hostile disputes and some very, very difficult situations. So absolutely, I entirely agree with that. I also accept, as you said, John, that it's difficult, and often people not wanting to have those conversations. I suppose the sort of second best thing is at least so that when a will is made, at least the person explains properly, and there's a proper record and a letter even that explains why that person is doing what they're doing. It sometimes can be a hostage to fortune. Sometimes you've got to be slightly careful about what's in those sorts of letters. But again, it's all part of communication. And in communication, I said, it can be difficult during lifetime, and sometimes messages can be, done as part of the will making process. The idea of a reading of a will is I think it only exists in movies. But
yeah, I was going to say.
But it does happen, we sort of joke about it, but I know situations where it's happened, and often in farming families where there's been a grand reading of the will, and there's been a reading of an accompanying letter that explains what's been done. So those things can help. There's no substitute, I don't think, for having the conversation during lifetime, but as I said, it's often not easy, and it is often a thing that is just ducks time and time again, because it's difficult, and because everyone sort of thinks, well, I'll sort it next year, I'll sort it in the future, and then of course something happens, and you haven't had those conversations. So it's
that's right, and in a sense expecting the unexpected in that regard, because bad things happen, and I suppose moving on from that, in terms of expecting the unexpected, it is getting your affairs in order, whether that be your will, taking proper accountancy advice as to how best to treat the assets in terms of tax, making sure that you've got an effective partnership agreement with a properly constructed schedule of fixed assets, so that you're just trying to narrow down all of those potential areas of dispute as much as possible. And I would say that in a farming an agricultural context, a will is not going to be pop into the solicitors, have a conversation, and come away with something in draft and sign it a little bit later. I think you can expect your advisors to want to understand more about the business, understand more about the family and the potential claims that people might have against the estate. When I say claims in that context, I mean that what their expectations might be and what they've been doing over a course of years in respect of the farming business. I think having a superficial view of those things from the sort of professional's point of view is a bad idea, because a bad will may be just as bad as not having a will. It could even be
worse. Yeah.
So it's having an expectation that you're going to have to provide your professional advisors with all the information, and be honest and upfront with them about, well, this person might have a view that they're expecting this or expecting that.
Yeah, and absolutely. And I would agree that it's about having, often there'll be different advisors. There'll be a solicitor, there'll be an accountant, there might be a financial advisor, there might be someone who's giving tax advice. It's about making sure that they all speak to each other. Because, I see lots of situations where they go off and do a will over here that looks great, it appears to deal with everything, but then actually there's no partnership agreement over here, or the partnership agreement doesn't actually, there are terms of the partnership agreement that mean that the will doesn't really work. So it's making sure that the advice is cohesive. Advisors are speaking to each other so that they can make sure that it all ties together. And the other thing would be to make sure that it's reviewed regularly. Again, you see situations where, you do a will, you go through you take the tax advice, you take the accountancy advice, you do it all, and then sits on a shelf then, and then suddenly all things, you might have had, we've mentioned divorce today. We had a question about divorce today. Someone gets divorced, someone dies, and things don't get reviewed. So it's that it's not just a kind of once and done. It's once and then review it, every 5 years. But, if anything in terms of family, marriages, divorces, deaths, you review anything at that point, really. So it's about keeping it under review. And it's, I said, it's not, if it's done properly, it's not a cheap exercise, but ultimately I think it can save an absolute fortune in terms of the comparative costs of a dispute if you don't get it right.
Yeah, absolutely. I think that it's putting yourself in order to avoid those disputes that we've highlighted. Of course, in difficult circumstances. I'm mindful that we're up against time now, and
1 minute to go. So
1 minute to go. So
well.
I'm not sure. I'm not sure whether we've got any other questions on the board. I
don't think so, but I think if anyone's got any questions that they want to ask us, either sort of general or specific ones, then obviously just don't hesitate to get in touch with either of us. I'd only be very happy to help.
Thank you very much for listening today. We do hope you found it useful. Don't forget to hit the subscribe button. And if you like what you've heard, please do leave us a review.